issue is like this. Now with the electronization and computerization of the returns of income, one cannot file return of income except as and by way of uploading the return. Physical forms have gone away. Secondly, I can file return of income only according to their prescribed format. What is happening is this. Up to 5th July 2024, they permitted income tax payers to file return of income claiming rebate under section 87A. So I need to step back and go a little historically. But in order to give concession to small taxpayers, for some time they went on increasing the amount up to which you don't need to pay tax. But that would mean that more and more assesses will go out of the radar of the department. So then what they did was, correctly, that if your income exceeds a particular amount, rupees 2.5 lakh, but you are not having so high an income up to rupees 5 lakh, you would be given rebate from the tax payable by you. And therefore, so long as you do not get tax liability over and above the amount of rebate, your liability will still be nil, though you will be required to file a return of income. Section 87A was inserted from 1st April 2014. Then what happened was, please go to section 87A, which is on page 24. But let me clarify where I'm actually going. They are not permitting returns to be filed making a claim for rebate. Now, whether I'm entitled to or not would be decided at the stage of assessment. How can revenue devise a form whereby SS is prevented from making a claim? That's the short question.
How can it be a question of public interest?
Because, my lord, this is a case of lakhs of small taxpayers. This concerns only those taxpayers where the rebate amount.
Individual taxpayer can always come forward
my lord,
and say that he has been deprived of claiming rebate and this is causing prejudice to him. But this cannot be a matter of, we are not the policy makers.
I'm not requesting a lordship to get into policy at all.
Yes.
I'm not.
Why form has not been provided? Why that column is not there? Cannot be subject matter of.
If in law an SS is entitled to make a claim,
then that particular SSC can always come to the court
and
say that I have been deprived of the claim.
Amount would be rupees 300, amount would be rupees 300, 500, 700.
Maybe 2 rupees.
Correct.
People can come to the court.
Can I request a lordship to look at 2004, volume 11 SCC, page 1 on the locus standi?
No, it's not about locus.
No, then, my lord,
it's not about locus.
Yes, then I may not cite the judgment.
The policy.
Okay.
It's about the prayer which you are making in the writ petition. We grant this prayer in PI.
Well, let's look at my prayer. My lord, what is it that I'm requesting a lordship to consider?
We cannot ask the department to
I would restrict myself
form to provide some like a space for that. That you can raise individual dispute before the department.
How can that be done? I'm sorry, it will not be possible. I tell you why it will not be possible.
No, you can always write to the higher authority to come to the court. But this is the prejudice which is caused to you.
The requests are made to the highest authority by Institute of Chartered Accountants.
The individual person can come in the relevant jurisdiction, and the court may ask for the reasons.
But if I have locus standi, obviously lordship will hear me.
No, it's not about
locus standi.
What do you mean by locus standi?
Whether PIL at the instance of a person who is not.
No, we are not on that question. We are on the question that the issue which you are raising as a matter of PIL is a policy issue which does not show any prejudice caused to any person individually. And the individual person to whom prejudice is caused can always approach the court.
No, but I'm answering the first aspect of your lordships. How does it cause prejudice?
We don't know.
But that's what I'm trying to explain to your lordship.
The individual person has to come forward that this is causing prejudice to me. I'm entitled for the rebate. It's not a question of deliberation.
But I'm not.
That everyone who is entitled for rebate should.
Please consider the aspect. He is not permitted to file return of income.
So then he should come forward.
I am
and approach the court that this is how he has been deprived. Of the benefit of the Income Tax Act. That particular person can come to the court.
But a particular person can certainly
can be issued.
A particular person can certainly come. Instead of lakhs of SSCs or some of the lakhs coming to a lordship.
1 or 2 will come. The court will pass orders. Everyone would follow.
But that's what I'm submitting.
See, 1 or 2 can come. And then this would be kind of an order, which would be order in rem. Then they have to follow. But it is not a question of PIL.
No, but if PIL is maintainable, lordship will examine it if your lordship
come. What we are saying is it's not a question to be taken in PIL. It's about the implementation of statutory provision. It is about deprivation to a particular individual of the right, which is a statutory right.
Correct.
So for asserting statutory right, that person individually has to come to the court.
But to that I'm submitting this wise, my lord. Please consider this aspect from this angle. I am putting up across case for persons who would have claim of amount ranging from couple of 100 rupees to couple of 1,000 rupees. those small people may not be in a position.
Anyone can come. It's not necessary that.
I'm not saying that they are not entitled to come. Question is, they would be too. They would have no reason to come for 100 rupees, 200 rupees, 500 rupees, 1000 rupees. Should, because the claim is too small for the people to go on fighting, the government.
That is not the ground to entertain PIL.
But to that, I was submitting to a lordship. Please have a look at from this angle, the judgment of the Supreme Court on PIL.
No, it's about the statutory right. Statutory right can be.
But this was also dealing with the statutory right, sir.
It's not about the public interest. It's about the individual right of an individual person who claims that I have a statutory right to claim rebate.
But what
it's about few or many persons who are individually affected.
But so far as this person, petitioner, is concerned, he would not be.
Of income tax and income tax rebate is an individual right.
No, it's an individual right. But can government devise a form so as to disentitle person from making a claim?
We will look into once you come in an appropriate jurisdiction. We will call. We will ask for the. We will make inquiry. We will ask for the.
It is at this stage. It is at this stage permitted to clarify as to why this is not correct.
It may not be correct, but what we are saying is that this is not a matter of PIL. This is the why we are saying so. We are saying so because of the fact that the right which you are claiming in the PIL is an individual right of an assessee, a particular assessee.
But ultimately, what is PIL?
Ultimately, what is happening is not.
Ultimately, what is PIL? PIL is in a way proxy litigation on behalf of those who are unable to litigate because of the smallness.
It's not the same.
Public interest litigation, the litigation for the benefit of public.
Same. And there is no Article 1421.
But please say, but then I was trying to rely on this judgment of the Honorable Supreme Court, where a chartered accountant approached the Honorable Bombay High Court, challenged all banks who were not granting refund of interest by rounding up the money. Issue was of fraction of a rupee. And the Honorable Supreme Court.
That must be generally applicable to everyone. Here rebate can be claimed by few.
No, but it can be claimed by every tax assessee who is entitled to benefit under Section 87A.
Right. So only those who are entitled to benefit under Section 87A.
But that, in case of Bombay Supreme Court judgment, it will be available to those only in whose case rounding up has taken place by the banks. If the rounding up has not been done, even that would not apply. Therefore, the fact that it is applicable to only those who are covered by the legislation with respect may not really be a reason not to entertain. Or if the lordships are so inclined, lordship put it beyond vacation, I'll join one or two persons who are actually affected by this.
No, not in PR. Bring their cases, it will go before the appropriate.
No, it would, but then, okay, then lordship may hear me and then lordship may, please have a look at this 2004 volume 11 SSC page 1. Kindly go to page 17. Para 32 onwards. Locus of the respondent. Writ petition before the High Court was a firm of chartered accountant as an expert in accountancy and auditing. So, para 32. Page 17, para 32. Writ petition before the High Court was a firm of chartered accountant. As an expert in accountancy and auditing, it must have come across several cases where its client had to pay a higher amount of interest to the banks pursuant to or in furtherance of the impugned action of the appellants. By reason of such an action on the part of appellants, as also Reserve Bank of India, as noticed herein before, citizens of India had to pay a higher amount of tax as also higher amount of interest for no fault on their part, save had been recovered from them without any authority of law. While entertaining a public interest litigation, this court in exercise of jurisdiction under Article 32 of the Constitution and High Courts under Article 226 thereof are entitled to entertain a petition moved by a person having knowledge in the subject matter of the lease and thus having an interest therein, as contradistinguished from a busybody in the welfare of people. Rule of locus has been relaxed by the courts for such purposes with a view to enable citizens of India to approach the courts to vindicate legal injury or legal wrong caused to a section of the people by way of violation of any statutory or constitutional right. In fact, courts had been treating a letter or a telegram sent to them as a public interest litigation by relaxing procedural laws, especially law related to pleadings. We did not dilate further on the subject as a bench of this court in so and so observed, quote, the courts exercising their power of judicial review found to their dismay that poorest of the poor, deprived, illiterate, urban and rural, unorganized labor sector, women, children, and those handicapped by ignorance, indigence, and illiteracy, and the downtrodden people have either no access to justice or had been denied justice. A new branch of proceedings known as social action litigation or public interest litigation was evolved with a view to render complete justice to the aforementioned classes of persons. It expanded its wings in course of time. Courts in pro bono publico granted relief to inmates of prisons, provided legal aid, directed speedy trials, maintenance of human dignity, and covered several other cases. Representative actions, pro bono publico, and test litigations were entertained in keeping with the current accent on the justice to the common man and the necessary disincentive to those who wish to bypass the real issues on merit by suspect reliance on peripheral procedural shortcomings. Court in pro bono publico proceedings intervened when there had been callous neglect as a policy of state, lack of probity in public life, abuse of power in control and destruction of the environment. It also protected inmates of prisons and homes. It sought to restrain exploitation of labor practices. Court expanded the meaning of life and liberty as envisaged in Article 21 of the Constitution of India. It jealously enforced Article 23 of the Constitution. Statutes were interpreted with human rights angle in view. Statutes were interpreted in light of international treaties, protocols, and conventions. Justice was made available having regard to the concept of human rights, even in cases where the state was not otherwise apparently liable. People of India have turned to courts more and more for justice wherever there has been legitimate grievance against the state's statutory authorities and other public organizations. People come to courts as the final resort to protect their rights and to secure the probity in public life. Pro bono publico constituted a significant state in the present day judicial system. They, however, provided the dockets with much greater responsibility for rendering concept of justice available to disadvantaged section of the society. Public interest litigation has come to stay, and its necessity cannot be overemphasized. Courts evolved a jurisprudence of compassion. Procedural propriety was to move over, giving place to substantive concerns of the deprivation of rights. Rule of locus standi was diluted. Court, in place of disinterested and dispassionate adjudicator, became an active participant in the dispensation of justice. Quote, unquote. Further, even where a petition has been held to be not maintainable on the ground or otherwise or lack of locus, court in larger public interest has intended writ petition in appropriate cases where the petitioner might have moved a court in his private interest and for redressal of his personal grievance. Court in furtherance of public interest may treat it as a necessity to inquire to state of affairs of subject of litigation in the interest of justice. Thus, the private interest can also be treated as a public interest. We therefore do not agree with the submission of learned counsel of the appellant that respondent had no locus to maintain public interest litigation or writ petition filed by him pro bono publico before the High Court was not maintainable. Number, what are the facts here? Here, what is the grievance? There are marginal taxpayers.
It's important that who raised the grievance.
Who am I?
No, in this matter, the grievance was raised
By
a firm of chartered
Correct.
accountant.
Yes.
Like they were raising no issue with regard to their personal interest.
I have no personal interest in the matter.
We don't know who are you.
I said in the writ petition.
We don't know who are you.
That Lordship will find in the writ
We
petition,
don't
please.
know who are you.
But I said so, madam. Please go to the writ petition.
You are an income taxpayer.
I'm an income taxpayer. I'm not affected by this.
So why would you come?
Because it's in the larger public interest.
No, you can't. You don't have any expertise.
I'm a chartered accountant. But I'm a chartered accountant dealing in the field of taxation. But I'm sure Lordship would not have any reservation about the knowledge of chartered accountant in the field of tax laws.
No, we don't have any reservation about that.
Correct. Now, but what is he? No, question is Lordship's question. Who is he? Please go to para 2. Page 4. The petitioner is a national and citizen of India, also member of the Institute of Chartered Accountants of India. He is carrying out his profession, is kept as a chartered accountant. He is a law-abiding citizen. He is living his life peacefully, residing at the address stated in the cost title, does not have criminal or anti-social background. Also contested in past contest as Central Regional Council election of ACI. Petitioner having very reputed status in the field of chartered accountancy. Petitioner has not filed any other PIL in past. And what I am claiming over here, Institute of Chartered Accountant has made representative to government.
Challenge this scheme.
Sorry?
Challenge this scheme.
No, I'm not challenging the scheme. I'm not challenging the scheme.
Yeah, there is a revised scheme. You are affected by this scheme.
No, I'm sorry. I'm not clear. I'm not challenging.
Please read paragraph 4.10.
4.10, I'll point out. However, it's a schema, it's not scheme. The schema is the computer software utility. Yes. But it's a computer software set up in the system to enable a citizen or a taxpayer to upload the return. Correct. So I am aggrieved by their software.
That can also be a reason for the individual to come forward.
But individual
will vote on the taxation bench.
But Lordship can be treated and send it to taxation bench. I have no issue. I can't really request a Lordship to do that.
PIL cannot be entertained.
But
the individual can always come forward that I have been deprived because of this software prepared by the income tax department, and this software has been made effective from 5th July 2024. So there may not be many people who are deprived as of now. This software is implemented. We are in October 2024. This software we are in October 2024. Correct. This software is only 5th July 2024. So you can always go to the tax bench.
Time to file return of income in their case would be over by 30th of June 24.
So they can still come to the court. But 30th June 2024 is already over.
Correct.
Now, 5th July 2024, this is a new software.
And
which would be applicable.
No. What has happened is people will file return of income up to August, up to September. And those who have filed returns even before 5th July 24, in their case, the amount which they had asked.
Already filed return.
Those who had filed returns of income to before and up to
now they are able to claim benefit rebate under section 87A because of this software. Correct. This is the only issue.
Correct.
That issue can very well be raised before the tax bench by an individual that he has been deprived of claiming this rebate and is falling in the category, and he has submitted his return in time up to June 2024.
the fact that it can be raised individually by a taxpayer.
For us, it becomes an academic issue. Mr. Suparkar, please try to understand.
Yes.
Then PIL deciding an academic issue, that too relating to application of a statutory provision, granting rebate to a person is not possible.
I am not asking.
We are not raising objection for the sake of raising.
No, I understand your Lordship's perspective. I'm trying to explain.
Try to understand our difficulty. We will not be able to adjudicate.
But then my submission is Lordship may delegate me to the tax bench.
Right? Not to this person.
If necessary amendment, I join. Please consider the issue.
Yes, you can withdraw this. We will permit you to file a proper petition by a person who is actually been deprived of getting this benefit because he has not been able to enter the relevant field in this software. So he has to make out a case that he falls tentatively, prima facie, he falls within the this scope of
Section 87A rebate.
And he's entitled at least to claim the rebate. He may not be entitled for the rebate, but claim can be put up.
It is my return can be uploaded. How can they deny me making of a claim?
You are, Mr. Suparkar, we are feeling a lot of constraint in passing any order in this PIL. Had we heading the tax bench and the person would have been there who has been deprived, we would have immediately asked for the response.
But probably that handicap is not actually there. That's what I'm trying to
please, Mr. Suparkar, please try to understand.
Yes, ma'am.
Deciding academic issue in any petition is a real difficulty.
It should not happen. I agree. But is it academic?
We know this very well. It is academic. Sorry. It is academic so far as the PIL is concerned. Has it been an individual claim? We could have adjudicated it.
Just give me 2-3 minutes. Please see in this regard.
No, just purely academic issue for the PIL.
Please kindly go with me for 2-3 minutes. Please go to page 35.
We are not about locus. We are about
please go to page 35. A detailed representation is made by Bombay Chartered Accountants Society on 18th July 24. So issue that I'm raising is not an issue for the sake of raising. 18th July 24, Bombay Chartered Accountants.
See, all these preparations are made for the PIL.
Yes,
representations are prepared for the purpose of filing PIL. Many times people do that.
Page 40. Representation is made by.
We are not having any kind of doubt about the intention of the petitioner.
Lordship is this.
We do not have any doubt about the competence of the petitioner.
Lordship is.
We do not say anything about the locus. But what we are saying is that issue for this issue which you are raising is an academic issue for the purpose of PIL. This issue can very well and effectively be raised before a competent bench by a person who is affected by this new software, and that can be raised.
But would your Lordship look at the prayer that I'm making? I'm going to insist for my Lord's consideration one prayer only. Please go to page 20. Para C.
Too many prayers for a PR.
I'm going to rely on prayer C and or G. Permit me to make a claim. Whether I succeed or not would be a matter.
Let an individual come and make this prayer in a tax bill.
But there'll be thousands of petitions. Why do we?
Single petition would serve the purpose. You do not need to file 1,000 petitions.
But a single.
One SSC can come forward.
But please see, let's look at the petition. One of the SS in the present case, he is denied the benefit of rupees 227.
He should come. That does not matter. For fighting for a cause, he can spend some money.
But he may really not be.
4, 5, 6 persons can join together.
But 227 multiplied by 6 will be 1,500 rupees. That will also not lead us to a significant amount.
We are feeling a lot of constraint in deciding this.
But it is try to ascertain from the revenue. Why are they not committing?
Then again, that means we are entering into an academic issue in a statutory right, which can be agitated by an individual who's deprived of that right.
Just give me 1 second. Would your Lordship give me 5 minutes?
Yes,
check out the petition whether I can withdraw with a liberty to move. I don't want to withdraw on my own unless he agrees.
Please.
Just check. I'll be here only for 5 minutes.
Here number 16, Mr. Shivan B. Mehta.
I've taken instruction, Lordship, permit me to withdraw, keeping all contentions open, including right to move learned at the appropriate court under the provisions of the Act.
After a brief submission, Mr. Saurabh Suparkar, and senior advocate, assisted by Mr. Ritvij Patel, an advocate appearing for the petitioner, would submit that the issue raised in the present petition may be permitted to be raised in an appropriate petition to be filed before the concerned tax bench. In view of the said raise for instance withdrawal would submit withdrawn. Present petition may be permitted to be withdrawn with liberty to raise the issues by an appropriate person before the appropriate tax bench. First off, in view of the said statement, the present writ petition is dismissed as withdrawn with liberty to the concerned person to raise the issue educated hearing. It is clarified that this court has not gone into the merits of the contentions in the writ petition and the merits of the issues raised in the
Lordship, immense obligation.
Right.